my name is Erin, and I'm an employment lawyer. And so what I do is I help companies develop contracts and deal with hiring and firing and putting together severance packages and dealing with complex human rights accommodation issues. Now it's a little funny doing this through video because I can't see any of you, and I don't know who you are or what you do or what brought you here. So just to make this a little bit more interactive and just to make sure that I'm giving you the content that you're looking for, I do encourage you to introduce yourselves in the chat box. Just maybe share your name, what your company is, and why you're here, and I can skim through that as we go a little bit. It'll just get me a sense of who I'm talking to, that I'm not just talking to a computer screen. It feels a little cold. So I hope you guys can all see my slides. If you can't, please type in the chat, and I will try and troubleshoot that. But otherwise, I will dive right in. So today we're going to talk about hiring and managing employees. I'm going to talk about a couple of different steps through this process. So I'll start with this question that comes up a lot for startups, which is, am I hiring an employee or am I hiring independent contractors? And so what does it even matter? And so I'll talk about what the risk of misclassifying is. I think that's my whole slide on that one. Yeah. So basically this matters because if you misclassify, so if you hire someone as a contractor, but they're actually an employee, it's possible that the CRA could come back and say, as an employer of employees, you have an obligation to deduct and remit income taxes and deal with things like CPP and EI, and you haven't been, and so you as a company are on the hook for that. Is same thing with the Employment Standards Branch. The Employment Standards Branch is a body which deals with the Employment Standards Act, and the Employment Standards Act sets out minimum standards, things like minimum wage, vacation pay, stat holiday pay. And if you call someone a contractor, but they are actually an employee, the Employment Standards Branch could come back and say, you owe this person all kinds of vacation pay, stat holiday pay, etc. So it matters, like getting it right is important, figuring out if you're hiring an employee or a contractor and framing the relationship properly matters, because if you get it wrong, then the Employment Standards Branch or the CRA could come after you for all kinds of compensation that you don't want to or never intended to pay. So what does it mean to be an employee or an independent contractor? And I'm happy to take questions as we go too. If something comes up that is burning, again, just feel free to type it in the chat box. I'm a multitasker. I skim and I can talk at the same time. And thanks everyone for introducing yourself. It's good to know who's here. So we look at a spectrum of factors, and the more factors that point towards independent contractor, the more likely someone is to be deemed a contractor. And the more factors that point towards employee, the more likely they are to be found to be an employee. So we look at things like, how much control does the company have over the worker? Does the company control how and when and where the work gets done? Or does the worker have a lot of independence in determining that for themselves? Who owns the tools? Is the company providing a workspace, office space, a phone, a computer, other business cards, uniforms, things like that? Or is the worker expected to provide all of that, all those materials and tools themselves? What's the compensation structure? If you have somebody on salary, that looks like an employment relationship. If you have somebody on, a fixed rate, like this is how much money you get, this is the job, and it doesn't matter how long it takes you, I don't care. Fixed rates look more like contractor relationships. Is the company deducting and remitting taxes or responsible for CPP and EI? Those look like employment relationships. Does the worker submit timesheets? That looks like employment. Or does the worker submit invoices and charge GST? That looks like a contractor relationship. Does the worker have a chance of profit or risk of loss? So when someone's being paid by the hour, the worker gets paid for their time, and that kind of looks like an employee. Or is it just a blanket sum that they get? And if the worker creates efficiencies, then they can create more profit. Or, is there a risk of loss if things don't go as anticipated? That looks more like an independent contractor relationship. How integrated is this person in with your business? The more integrated they are, like if you have a pizza delivery service and this pizza person is a delivery driver, usually that person will look more like an employee. They're very integral to your company. Or do you have a pizza delivery service and you're hiring someone to design a few posters? That might be less integral to your business. The length of the relationship matters. So if someone's been with you for 20 years working exclusively for you, that looks more like an employment relationship. If they work for multiple companies simultaneously and they haven't, it's a very short-term relationship, that looks more like a contractor. Can they subcontract their duties? So can they hire someone else to do the work for them? That looks like a contractor. And can they work for more than one company at the same time? Do you have that looks more like a contractor. Or do you have a non-compete and you expect them to work exclusively for you? That looks more like an employment relationship. So ultimately, when we are structuring these relationships, like I said at the beginning, the more factors that you have that look like an employment relationship, if you've called them a contractor, you bear a lot of risk that they could be deemed to be an employee. So if you really want to have contractors, and there's reasons for that in terms of, simplifying payroll as you're just getting started, then you want to make sure to err on the side of, independent contractor of all of these factors, or as many factors as possible on this spectrum. And that's the best way to minimize your risk of being on the hook for things that you didn't intend to be on the hook for. Oh, I need to go back to the other page to flip my slide. So once you've decided if you are hiring an independent contractor or employees or a mix of the two, then it's important to sit down and actually draft a written contract. I'm going to talk about some of the general principles of contract law. I'm going to talk about what terms you might want to include, the importance of clarity in a contract, and the importance of the timing of execution. I have a question here. If you have a contractor agreement that was valid in a province like Manitoba, can it be reused in BC? So in Canada, the employment law is very similar across all the provinces, with the exception of Quebec. Quebec runs on their own system of civil law, and I'm not qualified to talk about that, so I won't. I'm going to focus on the common law provinces, which is every province except Quebec. And so employment law, every province has their own legislation, the Employment Standards Act or something similar. And in every province, it's a little bit different. But the general principles are pretty similar. Now, I'm a BC lawyer, so my experience is in BC law. Manitoba, has an employment standards legislation that would be similar, but it wouldn't be identical. So it is smart or just prudent to have a contract that might have been valid in Manitoba just reviewed by a BC lawyer. It may be totally fine. There may be small nuances between the provinces that someone like me would pick up when reading it. So it may be fine if you're using something from Manitoba, but there might be some small differences. I was actually just going to talk about that. Thank you. What about templates from the internet? That is way more problematic. And the reason for that is because American law is very, very different than Canadian law. In the States, they have this concept called at-will employment, which is not a concept that exists here, which basically means that they can terminate an employee's employment without any notice or severance. And that concept does not exist here and is really, really dangerous to use in BC, because if you use it, I'm going to get into this a little bit more, but you can have some pretty significant severance obligations if you decided to let someone go. So my advice is, look, use stuff from other provinces, from friends if that's economical for you and it's a good template, but do not use American templates. Never, never, never use a written employment agreement that is originated from the States or is based on American principles. And I even see that, like, my friends hired a nanny last week and I looked at their contract and they had an at-will clause in it. And so I was like, please don't use that. And I think they did get it from a Canadian source. So just be really, really careful about using templates from the internet that include this language around at-will. The other again, this wasn't really part of my presentation, but the other difference between Canada and the US is really our approach to human rights. I think it's not just the law, but also the values around it in terms of, maternity and parental leaves and disability accommodation and things like that. So I would urge caution around that. So the general principles of contract law. I see your question. I'll come back to it. So a contract is formed when there is an offer of employment and there is acceptance of that offer. So that offer, acceptance, and the entire contract, the agreement between the two parties, between the employer and the employee, can be verbal or it can be in writing. And so, a lot of people come to me and say, I don't have a contract because there's nothing in writing. There is a contract, it's just verbal and it's just undefined and vague and unclear. So it's often really helpful that if you're reaching an agreement with someone to put it in writing so that it's really clear to everyone what the terms are, and that if the relationship goes south, that you can pull up that document or email even and just figure out what exactly it was that you agreed to at the time. Now, the terms that you should include in a contract are things like the duties. So what is it that you want this worker to do? And if you're talking about an employee, we talk about, job duties and job description. If you're talking about an independent contractor, we might use slightly different language around like expectations or deliverables. What's the work location? Is it a remote position? Is the employee or the worker expected to show up to a specific work location every day? What's the compensation structure? Salary, benefits, bonus, all that stuff should be in the contract. What are the hours of work? Is the employee allowed to work overtime, and will there be compensation for that? We usually include a confidentiality agreement, and this is really important, especially with tech startups, that the person not steal your confidential information and take it to a competitor or to their own business. How long is the contract going to last for? So we often will see a termination clause. Most contracts are for an indefinite duration subject to termination. So we'll have a termination clause in there. Restrictive covenants, and compliance with employment standards and human rights legislation. And I'll come back to these last three. I want to cover these in a little bit more detail. Keep wanting to hit next, but I have to switch screens and come back. Okay, so dismissal and severance. I'm going to come back to this one in quite a bit more detail towards the end of the session, but it's really important to have a very clearly written termination clause that is in compliance with the Employment Standards Act. And the reason for that is because there's a concept in law called contra preferendum, which basically says that if there's any ambiguities, then it's interpreted against the drafter. So, it's kind of a tough thing to do, but you can also think about it like relationships, that, everything's, personal relationships, like everything's great, and everything will be great with your worker so long as you're on good terms. Things like all these top clauses like duties, work location, hours, like as long as you have a good relationship, this is all stuff that you can negotiate and sort out. But once the relationship goes south and you want to end it, right, when you're trying to break up with someone, that's when things get messy and when you're no longer able to work out your problems. And so the bread and butter, I guess, a little bit to this question of what is my role as an employment lawyer. Part of my role is to help people draft contracts, help people review employment contracts and independent contractor agreements. But a huge part of what I do is fighting over dismissal and severance clauses. So somebody gets fired and they want more money, and that's most of what my job is. And so that's why it's really important to have well-written dismissal and severance clauses so that you can avoid having to hire someone like me to fight with your former employee over how much you're going to pay them now that you've fired them. And I'll come back to this one in a little bit more detail in terms of what should be included. Restrictive covenants. So this refers to things like non-competition clauses and non-solicitation clauses. Non-competition clauses are not usually something that we see in an independent contractor agreement. And if it's really important to you that the person work only for you and no one else, then you may want to consider hiring them as an employee. Because the courts are really, even with employees, the courts are really hesitant to restrict people from being able to earn a living. So these clauses, in order to be enforceable, they need to be reasonable in terms of duration, in terms of the geographic restriction, and in terms of the scope of what they can't do after working for you. So, this is something that's a little bit more finicky, and I would maybe not take something off the internet for a non-compete if you want to use one, and if your intention is that it actually be enforceable. We often do see companies including non-compete clauses that they received legal advice on, and they know they're not enforceable, but they just want to have that scare tactic in their contract. But often a lot of the ones that I review are really not enforceable. Non-solicitation clauses, on the other hand, are separate, and those are often enforceable. And the difference is that a non-compete restricts someone from working for a competitive company. So it really restricts them from working within their chosen field. Whereas a non-solicit says, you can't steal our clients, you can't steal our customers, you can't steal our employees. So you can go work for a competitor. You just can't be in a sales role where you're leveraging your personal relationships to come after our relationships. And so the courts are much more willing to uphold non-solicitation clauses, where they're often willing to strike out non-competition clauses. So again, the law around this stuff is a little bit complicated, and it is often good to get legal advice if this is something that's important to you and that you care that it's enforceable. And the last thing I want to touch on in this section in terms of terms is compliance with the Employment Standards Act and the human rights legislation. So you can never have a contract which falls below the minimum standards of the Employment Standards Act. So you can never have a contract which says, I'm going to pay you less than minimum wage, or you're going to work 80 hours a week and I'm going to pay you $15 an hour and there's never going to be overtime pay. Those contracts are completely unenforceable. And so it's important to, the Employment Standards Branch has a lot of free information on their website. They've got free fact sheets for employers. It's important to browse through that stuff if you're going to be hiring, get a sense of what your minimum legal obligations are, and just make sure that whatever you agree at least meets that. And if you're in a position or you're hiring someone more senior to be more generous than that, then fantastic. I encourage that. And same thing with human rights. Like, you can't have a contract which says, like, I really hope this is obvious to everyone, and I hope maybe if you're in the room, maybe you're giggling a little bit. But you can't have a contract which says, you can't get pregnant, or if you get pregnant, I'm going to fire you, because that's obviously offside Canadian law. What about anti-harassment policies? Yeah. Okay, I'm going to come to policies once I get to terms. I'm still dealing with terms in a contract. Policies, we generally have a separate document. That's usually not in the employment agreement. It's usually in something like a policy manual, and I'm going to come to that. What if I'm Walmart? I'm not sure what that is referring to, but I'm glad you find my comics funny. I like to have a little bit of humor. So I've already talked about this. It's important that the contract language be clear, because usually it's the employer who's drafting the contract. And so if there's any ambiguity, it's usually resolved in the favor of the person who didn't draft it, i.e. usually the worker. Do you need different contracts for different employees? Pizza delivery driver, marketers, development team, etc. I will usually, if a company is hiring just only employees, I will usually draft a single template for that company. Oftentimes when we get into the C-suite, we'll often see more comprehensive agreements for executives. There's usually more complicated stuff around, really complicated bonus structures, or stock option plans, or employee share purchase agreements. There sometimes are more robust confidentiality clauses or protection of intellectual property. So I generally use one template for all workers, and then I just adjust as necessary. I do see other lawyers who sometimes have, very short agreements for some workers, and much, maybe like 5 pages is my standard document. I've seen contracts as long as 10, 15 pages. I personally don't draft them that long. I'm not sure what it adds. So no, I think for a startup company, I think you can get away with having one contract template for all of your employees. The timing of execution is really important. The employee must sign the contract before they start work. There's a concept in law called consideration, where a contract, to be enforceable, there needs to be value flowing both ways. So when an employee starts work, the employer offers them compensation and a job and all these benefits. And in exchange, the employee agrees to limit some of their rights. So they agree to abide by the confidentiality clause and the non-compete clause and so forth. And so in order to be enforceable, the employee needs to get something. Now, where the employee signs the contract after they've already started work and they've already got all the benefits, and now you're saying, oh, wait, sign this and agree to be bound by confidentiality. That contract is often not enforceable because the employee is not getting something extra for signing it. So it is very, very important that even if you have like an amazingly drafted contract, that the employees sign it before they start work. Otherwise, it could all be for nothing. How do you incorporate flexible hours where the employees can work their regular hours during whatever time they choose? Okay, so that's a really complicated question, unfortunately. The Employment Standards Act is really rigid when it comes to overtime. The act says that an employee has to be paid a time and a half for when they work more than 8 hours a day or more than 40 hours a week. And if they work more than 12 hours a day, then they are entitled to double time. There are some exclusions. So there's some exclusion for high-tech workers. So workers who are involved in the creation and development of technology. So the sale of technology doesn't count. If you're like a troubleshooter who's reading a manual, that doesn't count. But if you're coding or creating technology, then the overtime provisions don't, there's exceptions for that. Otherwise, if you're paying someone significantly more than minimum wage, as long as we can draft that into a contract that, your hours are flexible and this is designed to compensate you for all hours worked, as long as there's never a situation where if you did the math on it and you said, okay, well, you worked, 20 hours in a day. And so divide that by, by the minimum wage plus overtime, and this is what you would have received. That's another way to avoid it. For lower paid workers, if you want to be flexible, then you have to hope that they're not going to file an employment standards complaint against you if things go south. That's the real risk, is that a lot of people just agree to agreements that are not in compliance with the act. And as long as the employee doesn't file a complaint, you don't have a problem. But if things go south and they get mad at you and they file a complaint, it would be within their rights to claim overtime if it wasn't strictly in a compliance. There's some stuff around averaging agreements, which I'm not going to get into right now. If I have time, I'll come back to it and remind me. Also, I'll be in the booth after the presentation. So if you have further follow-up questions, I can keep talking. But averaging agreements are also, it's one option, but those are also really inflexible. The reality is that our Employment Standards Act is outdated, and it needs updating to reflect today's realities around flexible work hours. So I'm sorry, I don't have a better answer. There are some ways we can get creative, but it's not an easy answer. Okay, so policies. Is there a rule of thumb or website to know how much equity or shares to give up to a certain role? Not from a legal perspective. There may be some HR guidance on something like that. If there's other people who have opinions on this, who can answer this question, feel free to weigh in the chat box. There's no legal obligations to give anyone anything. It's just a matter of what does the market dictate. So unfortunately, it's not a question I can answer as a lawyer, but I definitely crowdsource that one if there's anyone else who has an opinion. Okay, so these are the kinds of, when you're drafting a policy manual, these are the kinds of policies that I will, that are kind of the baseline for things that you want to include in your manual. And I'm going to get into a little bit more detail on a couple of these. So, if you haven't already dealt with it in your contract, you could deal with hours of work and overtime. If you might want to have an email, internet, social media policy. So, do you have are you in a type of company where you want your employees on social media, like sharing things about the company? And if so, what are the parameters for doing that? Are you going to prohibit, things that might hurt the reputation of your company? So no negative press. Conflict of interest policy, how you're going to use employees' personal information so that you commit to protecting employees' personal information in accordance with the Personal Information Protection Act, and that you're only going to use personal information for the purpose for which it was collected. Absences and leaves, I think I'm coming back to. Remote work policies, I'm going to come back to. Workplace safety, bullying, and harassment. I'll deal with some of these other ones a little bit later: bullying and harassment, discipline, substance use, and so forth. So this will just kind of give you like some baseline headings of policies that you might want to include. And if you don't have the budget to hire a lawyer today, these are the kinds of things that you can often find on the internet and co-opt for your personal use. Again, as long as you're making sure that you're complying with Canadian human rights law, and then especially when you get into things like substance use and absences and personal leaves, that you're complying with the BC Human Rights Code and the Employment Standards Act. Okay, a lot of questions here. I will endeavor to share these slides. If for whatever reason I can't do that through Vancouver Startup Week, I'm going to have my contact information on the last slide. It's my name, Erin, at PortaLaw.ca, and you can always email me, and I'm happy to share them. Should all workers have an employment contract? If I hire someone to do a poster, a small job, the money is not worth the trouble. Yeah, I mean, that's up to you. Like, if it's just like a one-off, like very small job, not significant, then maybe you don't need like a very comprehensive employment agreement, like a 5-page document. But I still think it's important to at least document what the key terms of your agreement are. So even if it's in an email saying, this is what I expect you to do, this is the deadline, and this is what I'm planning to pay you, is that acceptable to you? And if the person says yes, that's a contract, right? It's an agreement between the two parties where there's mutual benefit. And so I would encourage you in that situation to at least put the details in writing in some way. I have a company incorporated in BC. Is it possible to hire someone non-Canadian who lives abroad and pay the person in the local currency? That's a little bit more complicated. I'm going to come back to that one, if that's okay. And if I don't get to it during my time in this presentation, feel free to join me in my booth afterwards, and we can chat a little bit more about it. Okay, so I want to talk about remote work policies. So these are just some general concepts that you want to think about including. So who is eligible for this? Can anyone work remotely, or is it only people in certain positions? What are the core work hours? Are you expecting that people are going to work 9 to 5, or is it kind of a free-for-all and people can do what they want? How responsive are people going to be? If it is a free-for-all, are you still expecting that people are going to be on their emails, like responding within an hour, within 5 hours, same day, 24 hours? And how do you measure productivity? Are you setting, like when you have employees, like if you're not near them and you're not talking to them every day, like how do you measure that they're actually working and not just watching Netflix all day? So setting some parameters for maybe reporting in and saying, these are the things that I accomplished today, or this is my weekly goal. Workspace, you want to make sure, like as an employer, you have work-safe obligations to make sure that the workplace is safe. And so you want to make sure that extends to the home, and there's some work-safe policy on this. You want to make sure that the employee has a safe workspace. Do they have, especially through COVID, these are things we're talking about a lot. Do they have an ergonomic setup at home? Are they going to develop repetitive strain injuries? Can they take the stuff they had at the office, can they bring it home if they had a chair or a keyboard or something that was special? Who's supplying the equipment and supplies for the home office? Are you expecting the employee to buy their own stuff, or are you going to supply it for them? And how are you dealing with confidentiality and security? Do you have a cloud? Is there password protections? Like, is the employee expected to put sensitive documents in a locked filing cabinet? Is the employee's internet network at home, is it secure? And I talked a little bit about workers' compensation already, that, workers' coverage, I think it does cover the person while they're working at home, and you just need to make sure that the employee's work safe is safe. that they're not going to get injured. So, one thing I've heard about is like cords everywhere. Is the employee going to trip over a power cord and hurt themselves? And are you going to be liable for that? Absences and leaves. So the kinds of leaves we consider are things like how much paid vacation is the employee entitled to? And the Employment Standards Act says that in the first 5 years, they're entitled to 2 weeks paid vacation. And after 5 years, it's 3 weeks at a minimum. Their act was recently modified. There's now a requirement to give a minimum of 3 unpaid sick days to all employees. You could choose to be more generous. You could choose to give paid sick days. And what's your policy around that? The Employment Standards Act also sets out a whole bunch of other leaves, things like critical illness or injury leave, bereavement leave if someone in the employee's immediate family dies, family responsibility leave to care for dependents, compassionate care leave. I know these are all really overlapping and they're all have very specific definitions around how sick someone has to be and who qualifies. These 2 are new: leave respecting death or disappearance of a child, or leave respecting domestic or sexual violence. There's specific provisions around how long an employee is entitled to have unpaid time off and have their job held for them until they get back. Luckily, those are not ones that I've dealt with yet. Reservist leave, employees entitled to time off for jury duty or to vote, other unpaid leaves. The ones that I deal most often with would be stat holidays, maternity and parental leave. The Employment Standards Act talks about the employees being entitled to 18 months off for maternity leave. And there's a similar provision for, I think it's like 62 weeks or something for parental leave. And so an employer's obligation is to hold a job for an employee who's off on these protected leaves. When providing employees with a leave policy, is it important to include all types of leaves? This is kind of just gravy, like this is extra. I would say like larger employers tend to have these policies really clearly written out. The law does change from time to time. So the risk of writing them out is that the law could change and you wouldn't notice. And so then you might not be in compliance if you're a small employer and you're just trying to deal with everything all at once if you don't have an HR team. You could also have something that says, the Employment Standards Act has all these different leaves and go look at it. You could also, you don't have to have, there's no legal obligation to have these policies in writing. You don't have to. Just be aware that these legal obligations exist. And like I said, the Employment Standards Branch does have a lot of fact sheets on this stuff. So you could also print off some of the fact sheets and just call those your policy. That would also be fine. I don't think it's important to outline every single type of leave in a policy manual. It's just, I think it's a good HR practice to do it if you have the capacity to deal with this. This one though, bullying and harassment, this is really important. WorkSafe BC actually does require that all employers have a bullying and harassment policy and that they follow it. So they also have really great free templates. So you can go on their website and download their template policy and template guidelines. So this is really easy to implement. If you don't have a policy and you have an employee who makes a complaint, then WorkSafe will come in, investigate, and order that you implement a policy. But it's really easy to do. It'll take you like 5 minutes to figure out. So I would definitely encourage you to just go ahead and download the one from WorkSafe BC. And then make sure you understand it, that you train your employees on it, and that you follow it. And that could be as easy as sending around an email saying, hey, everyone, we have this policy. Any questions, let us know. I've adopted the WorkSafe BC policy. I'm curious about contingencies. For example, if an employee wants to escalate beyond the CEO, the contact person there is a bit uncertain as to who would do this. So if the company has a board of directors that the CEO reports to, you could have a reporting, you could have if this complaints about your manager, take it to the CEO. And if the complaints about the CEO, take it to the board. If the complaint is, if it's about a board member, bring it to the chair of the board, or if it's about the chair of the board, bring it to this other person on the board. If the complaint is about the person at the top of the food chain, those are more difficult. Those are difficult, and it's hard to develop a policy on that. You could maybe say, if this is about the person at the top of the food chain, maybe go to the person that's directly under that person. But realistically speaking, the reality is that when employees have complaints against the top person, it's hard to get a remedy. Oftentimes, let's say there's 3 people working for a company and one of them is the CEO, and one of the workers has a complaint against the CEO, I mean, those are just not going to be viable employment relationships, and perhaps another solution is needed there. Thank you for sharing the link to WorkSafe BC. I appreciate that for anyone who wants it. Okay, so substance use. You should have a substance use policy. I actually heard from we had a forum on this a couple of years ago, and most in safety, we talk about safety sensitive work environments versus non-safety sensitive work environments. If you're operating heavy machinery, it's really important that people not be impaired. In non-safety sensitive work environments, like we heard from some people in creative, and they were like, oh, we all microdose on the roof sometimes. Like they don't want to prohibit substance use in the workplace because they feel it helps their creative juices, but it still is important to have policies around that, right? Like if people are becoming impaired in the workplace and then maybe getting in their car and driving home, I mean, an employer could possibly be on the hook if there's an accident. So even in a non-safety sensitive work environment, it can be smart to have policies around this kind of thing. And we talk about recreational use versus medical use. So where an employee is impaired for recreational purposes, an employer has a right to say you cannot be under the influence of recreational drugs or alcohol while you're at work. But we talk about medical use, then I'm not going to go too far into this, but it then starts to raise human rights concerns around accommodation. If an employee, for example, is impaired on T3s, because taxes versus drugs, it's all the same, right? If an employee is impaired because they're taking T3s or they're using medical marijuana, we get into this human rights framework around the duty to accommodate versus recreational use, where an employer with a policy may have a right to discipline an employee who's showing up to work impaired. Okay. So step 4, the next step, also impairment measurements would get involved there. Totally. I mean, this stuff gets like, I've done an entire hour-long presentation just on this issue of medical marijuana and, the human rights code obligations to accommodate versus, employers' right to discipline. So this isn't something that most startups are concerned with on day one. Most times when I present at Startup Week Vancouver, people are more concerned about how do I get a contract, independent contractor. So that's where I've chosen to focus today. But if this is an issue that is of interest to you, we can always follow up and talk more about it at a later date. But in terms of discipline, we've talked about starting the relationship, setting it up, framing it, developing policies. But what happens when things start to go a little bit south and an employee isn't performing? And so that's why it's important to have, it's a good idea to have a discipline policy, which sets out what process you're going to follow if you're going to deal with discipline. So policies will often start with things like, you get one verbal warning, and then you get a written warning. And then if that doesn't work, we talk about a performance improvement plan, which is really this written document which has to establish a clear performance standard. So I expect you to do X, Y, Z. It warns the employee that they're not meeting the standard. So, we expect you to do X, Y, Z, and so far you're not doing that. And it gives them an opportunity to improve. So, we're going to meet weekly and do check-ins and talk about, what you can do to improve your skill set. And it warns of the consequences for failing to improve. So what happens if the employee doesn't do better? Like nothing? Are there consequences, further discipline? Or even, are they facing the possibility of dismissal if they fail to improve? It's often hard for small companies to follow these formal discipline steps. And this is something that really often gets left behind, even in larger companies with HR departments. This stuff, it's time consuming and it often gets left behind. So don't panic if you're not dealing with this. It's not the end of the world. And I'll come to you a little bit later why it may be important and why it can be helpful to follow this process of performance management. I think from an HR perspective, it helps to create expectations for the employee and document it and give them, clear measurable targets. And the follow-up around, further discipline and potential for dismissal is really something that if you're heading down the course of wanting to end the relationship, it can become important. Okay, so this is kind of the heaviest topic. So dismissal. This is really, like I said, the bread and butter of where I spend my time, this and human rights, which, yeah. So I'm going to talk about the Employment Standards Act, the common law, contract law. I'm going to talk about principles of just cause and some other things that you might want to think about. So like minimum wage, the Employment Standards Act sets out these minimum expectations when terminating an employee without cause. And so it's based on length of service. So where an employee has been with you for less than 3 months, there's no minimum obligation to pay severance or give notice. When they've been with you for 3 months, but less than a year, you have to pay at least 1 week of severance or give at least 1 week of working notice. After 1 year, but less than 3 years, we talk about 2 weeks, more than 3 years, 3 weeks. And then it's an additional week per year of completed service to a maximum of 8 weeks. And when I say maximum, I mean like after an employee's been with you for 8 years, the minimum requirement is to pay them 8 weeks of severance or give them 8 weeks of notice or a combination of the two. So it's not, the employment standards minimums are really not that significant. The common law, though, is where things get more interesting. And this is why it's so important not to use American contracts that talk about at will. At common law, and this is generally applicable across the English-speaking provinces, we look at a rule of roughly 1 month of severance per year of service to a maximum of 24 months. So we look at the employee's length of employment, the nature of their job, their age, and the availability of similar work to come up with a number that makes sense. So if you, I'm going to come back. Yeah, I'm going to flip and then I'll come back. So through contract law, you can contract out of the common law. You can never contract out of the Employment Standards Act. So you can have a clause which says, in the event that we decide to dismiss you, you get what's in the Employment Standards Act. You get no more than what's in the Employment Standards Act. So you can say you don't get common law. You don't get 1 month per year of service. You get roughly 1 week per year of service up to a limit of 8 weeks. And so that's why termination clauses can be so important, because you could have an employee working for you for 10 years. And if you don't have a written contract, the default could be roughly 10 months of severance pay. Whereas if you have a written contract with an enforceable termination clause, it could be 8 weeks. And so that becomes a really material difference as you grow. And if you're in a position where you're trying to create this company and then, the goal is to try and grow it and then sell it, having your employment law matters in order. So having all of your staff on these enforceable contracts with limited termination clauses, I think that is appealing. I think it can be appealing to a buyer that everything's in order. Now, these same principles don't really apply to independent contractors, but it can apply to this category of workers called dependent contractors. And a dependent contractor is where you've set it up like an independent contractor relationship, but the worker is really working exclusively for you, and there's this really long-term relationship, and the worker is effectively dependent on one company for their sole income. And so the courts say, that person is kind of like an employee. They're a dependent contractor, and they can be entitled to common law severance. So again, that's why it matters how we set up the classifications. And it doesn't matter, what's important is what's actually happening on the ground, not the terminology that we use. And so it's important to be aware that you could call someone an independent contractor. They could work for you for 20 years, and you could fire them thinking that your 30-day or your 30-day clause is enforceable, and it might not be. So it's just important to have next slide. It's important to have a clear, unambiguous severance clause which sets out the employee's financial entitlement upon dismissal. It's important that the contract was signed prior to the employee's start date. And it's really important that the termination clause complies with the minimum requirements of the Employment Standards Act, so that at no point in time would the employee get less than what's in the Employment Standards Act. And that's why the at-will contracts are so problematic, because they don't comply with the BC Employment Standards Act, and therefore it makes basically the whole contract unenforceable and irrelevant. All Are employment contracts signed concurrently with employment, same day? Okay. So, I mean, this one's a little, usually fine. Like if the first thing that they do is like they show up to work and they sign the contract before they start working, those contracts will generally stand up. The best practice is to have the contract signed and returned before the employee's first day. So where the employee shows up to work and they start working, you say, oh, by the way, sign this contract, I forgot. And they sign it right then and there. Those contracts are more problematic because like they haven't had a chance to review it. They may feel that there's duress. They've signed it after they've already started working, like they had no notice of this before they accepted your job. So those contracts are problematic. But where you've given it to, the employee a week before their hire date or a few days before their start date, and they show up to work and say, here's my contract, I'm ready to start working, that could be okay. So I guess the answer to your question is there's a little bit of gray in terms of having the employee sign it on their first day of work. Best practice is to have it signed and returned before their first day of work, or at least before they start working. Now, if you get 5 years down the road and, because I work for employees too, and I'm like, oh, you signed this on your first day. Did you sign it before you started working or after you started working? And they're usually like, I don't know. I don't remember when I signed it. So there can be some gray there and some ambiguity if it's signed on the first day. If it's signed on the second day or later in the week, that's problematic. Okay, some other things to consider. So contracts will often have terms around bonus, commission, health benefits, stock options. And it's important to think about what happens to all these pieces of an employee's compensation if they're terminated. So bonus is one we fight about a lot. Like what happens if the employee was about to be paid a bonus next week, but you fire them today? Did they earn that bonus? Are they entitled to the whole thing? Are they entitled to a prorated amount? Or does the employee have to be actively employed, i.e., actively employed to get that bonus? Or, if the bonus payment, like let's say they're entitled to 4 weeks of severance and they were going to get the bonus during that severance period, are they entitled to that? So this stuff can get kind of complicated, and it's really important to be expressly clear about what happens to something like a bonus, especially where it's a significant part of the compensation package if the employee gets let go. What happens to commission payments? Again, we fight about this a lot where there's ambiguity. Is it prorated? Does the deal have to close? Does the client have to have paid? Or do you, fire the employee thinking that your relationship is over, and then for the next year, you're still fighting about commissions? How long will health benefits continue for? Stock options, this is something that is usually governed by the terms of the stock option plan. And at common law, like if you don't have a contractual clause, an employee has a duty to look for work. And if they find work, it can reduce what the employer owes them. So this is I don't see this very often and I don't recommend it, but sometimes there's a clawback provision. Like if you're going to be more generous than the Employment Standards Act, let's say you want to give like 1 month per year, 1 month severance per year of service. You could, in theory, have a clawback clause that if the employee finds work quickly, that it's going to be paid a salary continuance, and the continuance will stop if they find a new comparable position. So these are things that we think about when we're drafting. This is like again, this isn't kind of your basic template clause, but these are things that we do think about when we are drafting termination clauses. How many more slides I have? Okay, just one more slide. Great. And so just cause. Just cause is where somebody has done something so serious that strikes at the heart of the employment relationship, and the employer can fire the employee without any notice or severance. And so I usually describe just cause as something that would shock me as an employment lawyer. So things like, like if somebody steals from you, or they're dishonest, or they assault somebody at work, or sexually harass someone. Those can be the kinds of things that happen where, you may have cause to fire someone on the spot without severance. Performance issues over time can be just cause where you have met the criteria for performance management. So where you have articulated a clear standard, where you've told the employee that they're not meeting the standard, where you've given them an opportunity to improve, and you've warned them that a failure to improve could result in dismissal. Where you've engaged in this process, like multiple warnings in writing over time with that criteria, that can, in some cases, be just cause. Even where you think you have just cause, sometimes you still might not. Just cause is a really, really high threshold, and the burden is on the employer to prove it. So even where an employer has just cause, I often say, it's easier just to pay them severance if they have a really tight severance clause. So this is just something to think about in terms of, it's why that performance management process can be important, is because if at the end of the relationship, you don't have an enforceable termination clause and you want to fire someone because they are just a terrible worker, you may be able to do that without severance, or you may have some negotiating leverage to reduce the severance package if you have engaged in that performance management process that I outlined earlier. So that's basically all I wanted to cover for today. We covered independent contractor versus employee classifications. We covered what are the important things to include in your employment contracts. We talked about policies that you might want to have. And we talked about employee terminations and performance management issues. So again, my name is Erin Brandt. I'm the co-founder of a law firm called PortaLaw, and we're trying to do law a little bit differently. We offer fixed fee services. So I guess to the question of what does an employer do and how can you help me? We've got these startup boxes for no, I'll just leave you on the slides. That's fine. We've got these startup boxes for startup companies, which include things like contract templates and fact sheets, different kinds of fact sheets to give you free legal information. On our website, we have something called Open Porta, which maybe I will take you to Open Porta. We've got something called Open Porta, which we're currently preparing. It's still drafting, but it's basically got like all of this free legal information. The idea is that if you can find it on Wikipedia, then we should be giving it to you too. And so, but it's stuff that's drafted by a BC employment lawyer. So it's hopefully of a higher quality than what you might find on other sources. And so we've got these different sections on some popular topics that we cover. So, dismissal and severance, we've drafted already, and it's got like a lot of the stuff that I've covered during this presentation today on the different things that you want to think about. And so this is actually a project that as a new law firm, we're still building out. So there's going to be lots of content continuing to come over the next few weeks and few months. So if you follow us on social media, you'll hear about when the stuff gets updated. Yeah, and like I said, we've also got these startup services. So we've got this program called Access Porta for Business. Most employment lawyers will charge you, for every phone call that you make to them. We've got this service where you can subscribe and you can call us or email us as much as you like with as many questions as you want. We've also, like I said, got the startup box, which includes different levels of what's included. So different kinds of contract templates, policy manual templates, and how-to guides and things like that. So I'm happy to take questions. If anyone has any questions. I'm also going to be in the booth immediately following the presentation. Paulina says, I'd like to invite you to check out the expo area afterwards to visit my booth, or if you'd like to continue the conversation. So yeah, I will be there. Well, thank you. I appreciate the compliment. It's brand new. We only launched in August, but I have been an employment lawyer for quite a bit longer than that. No, you cannot withhold pay. Developer not running documentation when it was part of their job duty, student interns, can you withhold pay? No, if they're an employee, you have to pay them for the work that they do. So if they say that they worked an hour, you have to pay them for that hour. And that goes to performance management. Like if you don't think they were actually working, then we engage in this performance management process until they deliver. No, the employment relationship is not based on an employee accomplishing their job duties. It's based on the time that they're working. So if they're not doing their job, you could fire them with or without cause. That would be your options. virtual interns and best practices or anything that creates risk there. I'd refer back to the slide on remote work policies. I think that those concepts apply to virtual interns like any other staff. Are you talking, I guess the question is whether you're talking about paid interns or unpaid interns, which raises a whole different host of issues. Best practices, I mean, that's just hard, right? Like these aren't unpaid interns. So under the Employment Standards Act, you have to pay someone, like an employee, someone's an employee if they're doing work that you would otherwise have an employee doing. And so the Employment Standards Act, it gets complicated around unpaid interns. So many questions. So the best practices for unpaid interns would be to make sure that they're doing work that would not otherwise normally be done by an employee. Otherwise, you could be on the hook for having to pay them minimum wage for the work that they're doing. You could, if they're deemed to be, the definition of worker is incredibly broad under the WorkSafe legislation. So make sure you're in compliance with your WorkSafe obligations, even for unpaid interns. And I guess just make sure that they're getting value, that the reason that they're volunteering for you as an intern is to gain meaningful experience that's beneficial to them. Otherwise, like if they're not getting any benefit or relevant work experience, then they should be an employee. So just make sure that they're getting a good experience and that they're, resume building or getting school experience or school credit or whatever it is that they've, the reason why it's an internship and not an employee. When do the common law severance periods come into play? Is it when an employee who doesn't have a contract threatens a claim? Yes. So everything is great until it's not great. And so these become problems when you have an employee who doesn't have a written contract and you fire them, and then they go see an employment lawyer and they're told that they have a legal claim against you, and now they're threatening a claim. So our system is like complaint driven. So if someone doesn't complain, then you don't have a legal problem. But if someone complains, then you have the potential for a problem. And my goal as an employment lawyer is to help you get in front of those issues and avoid them.